When will a demolition of property be lawful? We'll be right back. This is the law. It's your legal lights. It is your help law. I'm Samson Ladia Nyenini. I'm reading to you from a judgment, Laye Mate and Mohammed Tahiru versus Abubakar Mohammed and Jamil Idris, where the Supreme Court gave a judgment on the 8th of November, 2023. And at the end of the judgment, this is what the court had to say. And I mean the Supreme Court. That is the final court in the land. We have taken note of the grant by the first court of an order of demolition as a form of execution of the judgment of the court. There is no rate of execution in the High Court, Civil Procedure Rules 2004 CI 47, called demolition order. Judges are not at liberty to invent their own practice rules without any authority of the Rules of Court Committee pursuant to Article 157 of the 1992 Constitution. There has been abuse of such unauthorized orders that have brought embarrassment to the administration of justice. We accordingly set aside the order of demolition in suit number so as having been made without jurisdiction. Once a judgment creditor is put in possession of land, execution is completed and the judge becomes functus officio as far as the case is concerned. The party in possession is free to do as he pleases with his property, provided he acts within the law. The judges who sat and gave this decision are Justice Enes Jehu, Justice Gabriel Poaman, Justice Mariama Owusu, Justice Professor Henrietta Mensah Bonsu, and Justice Asiedu. So let me now bring in my guests, beginning with Veronica Frimpong, Mrs., who joins us via Zoom. She is former legal officer, Lands Commission, and head of legal, and used to be head of legal at SIC Life Savings and Loans. But presently, she is lawyer with Lex Kudos Legal Consult. So what does this mean? How do you explain what the Supreme Court has said in this judgment to our viewers? Veronica.
Hello, good afternoon, Samson.
Good afternoon.
And good afternoon to the listeners and viewers. The Supreme Court is simply saying that when a person has judgment and an order is made for recovery of possession, the court has a duty to put the person in possession. After the person has filed the necessary processes, you file the writ of possession, ensure that the notice is served. The Supreme Court is saying that once that has been done and you follow the processes through and you have recovered possession, the property becomes yours and you do as you please with it. Don't go back to the court to ask for a demolition order in order to demolish a property which is now yours. So simply that is what the Supreme Court is saying by this judgment.
So, differently put, if I understand you, I have land belonging to me. Somebody has wrongly come onto the land or trespassed onto the land, and they have built on the land. It is possible, just like in this particular case, The land was sold to one person and sold to another person. Two people, double sale, we call it. And the person who built on it up to a certain point is the one being said, you don't own it. So once the one has gotten judgment, they have asked the court for a demolition order, and the court has given them the demolition order. They have the power to come and demolish the property. Your explanations is that I can get judgment to say, yes, the property is yours, the land is yours. If somebody has built on the land, the building on the land is equally yours. You decide what you do with, but the court will not give you an order to demolish that building. Is that what you're saying?
Yes.
So what should I do as a victor? I have been given judgment. What should I do?
Something they are saying that you've been given judgment that to recover possession of your land because the land is yours, at least after the court has assessed the evidence of both parties and has concluded or come to the determination that the land is supposed to be for party A, who is the judgment creditor. The court goes ahead to say, recover possession from the other party, the judgment debtor, who probably has possession because he's the one doing the construction on the property. Now, once you get the order, you just don't get up and go and take the property. You will file entry of judgment. Then you would file the writ of possession. There are processes that you go through. You get leave of the court. You file the notice of the writ of possession on persons who are in occupation of the property. The law gives the processes that you have to go through. Now, once you notify the police sometimes because you have to physically go sometimes to take up the property. The Supreme Court is simply saying that once you have done everything and you have taken possession of the property is now yours. If you have your land, something, and you want to do something on your land, demolish something, a property on your land, the Land Use and Spatial Planning Authority also has regulations or rules that you have to get a demolition permit. So go through those processes, get your demolition permit, and then you can do as you please. But I believe the Supreme Court is simply saying that you don't need to come back to the court for further orders in order to deal with a property that has been declared to be yours and for which you have been asked to take possession of. So simply that's my understanding of what the Supreme Court is saying.
Emmanuel Bright Atoko is head of chambers at EBA Law. What's the court telling all of us? That I have come to court and I say, this land is mine. The wrong person has come on it. That wrong person has built a property on it, whether dwelling or commercial property. At the end of the case, the court says, yes, Samson, you are victorious. We have declared the land is yours. Go and take over your land. But a judge should not make an order for demolition for you to go and demolish the property. We don't understand.
Samson, thank you very much. I am speaking from the point of view that very soon I'm sure the Supreme Court will reconsider this decision, because I can tell you for sure that the circumstance that has been portrayed has actually created a lot of challenges in the execution of judgments, especially those in respect of land. Land issues are becoming a national security issue in this country, all because people will enter into other people's land. They are taken on before the law courts. Judgment is given in their favor, and they cannot get peaceful and quiet possession of the land that they have been adjudged to recover. The issue borders on whether as the Supreme Court has given us, shouldn't the court have the power to demolish or to order demolition of structures? With the utmost respect to the Supreme Court, and that is why I said that I'm sure very soon the Supreme Court will depart from this decision pursuant to the provisions of the Constitution in Article 1293 of our 92 Constitution. The reason being that if you read the Constitution, if you look at Article 125, you look at Article 126, especially Clause 4, which, if I may refer you to, if I may read.
Please do.
For all of us to gain some edification, this is what it says. So Article 1264. In the exercise of the judicial power conferred on the judiciary by this Constitution or any other law, the superior courts may, in relation to any matter within their jurisdiction, issue such orders and directions as may be necessary to ensure the enforcement of any judgment, decree, or order of those courts. If the constitutional provision states that the courts, that is the superior courts of judicature, could make any orders or directions to ensure the effective enforcement of their decisions or orders, I would think that such orders include demolition orders, because demolition orders will ensure that a victorious party gets peaceful and quiet possession of the land he has been adjudged by the courts.
But let's begin from the premise of this decision.
Yes.
Doesn't it make common sense? You say the land is yours.
Yes.
The court has adjudged you and said, yes, it's yours.
Yes.
We have given it to you. What you do with what is sitting on the land should not be the business of the court, should it? If you want to demolish it, if you don't want to demolish it, the person who did it wrongly, maybe you want to demolish it, or you want to say, I'll give you 2 cedis, get out of the place.
Samson, you would agree with me quite recently we have introduced the court shift system. And I can tell you for sure that most of the cases, especially those relating to land, they are just a recycling of the same cases in respect of land. There was a ruling by a judge of the High Court on a contempt application some time back. And in that ruling, the court referred to the respondent's continuous and deliberate refusal to accept that they had lost the case. The reason being that this respondent had some structures on the land. And in fact, the court went further and said, look, you have some sentimental attachment, and which is true. Every person who constructs a structure or a building on land has some form of attachment to the land. Because of this attachment, it becomes very difficult for judgment debtors in respect of land to easily give up. Now, my issue is, or my take is that if the court makes an order for such structures, unauthorized structures, to be pulled down, that issue of sentimental attachment will no longer be there. That is one. Secondly, there will be some form of fear in the system where people will be afraid that, yes, if I expend money to put up structures on land and I am declared not the owner of land, I am likely to lose the structure and my expenditure and everything will go waste. I'm sure people will be very careful when dealing with other people's land or landed property. And that will help us go a very long way to control these land issues, the unlawful demolition. This one says, this have been adjudged the owner, and the other person says, look, I have my structure on the land. I will not give up possession. Even if you send the person, you cite the person for contempt, he goes to prison, he comes back, and he is still fighting over the same land. These are issues I think we have to address as a nation. And to my mind, demolition should be part of the orders that, or the reserve orders, the inherent, that should form part of the inherent powers that the court should have to ensure that every person who is a judged owner of land has peaceful possession of the land adjudged. And
you are saying you are looking at that inherent power of the court from Article 126, Clause 4. Which says that in the exercise of the judicial power conferred of the judiciary by this Constitution or any other law, the superior court may, in relation to any matter within their jurisdiction, issue such orders and directions as may be necessary to ensure the enforcement of any judgment, decree, or order of those courts. But what's your understanding of what the Supreme Court has said in this case? Basic. If you're explaining to that person who, doesn't know law and wants to appreciate, what will you tell them? What does the Supreme Court say?
What the Supreme Court simply says is the court has no powers to order demolition. Basically, that is what the decision is saying. And that is why I said that with the utmost respect to the court, and I'm sure very soon, the Supreme Court, which is the apex court of the land, and has the powers to depart from its ruling. I'm sure a time will come, the Supreme Court will certainly depart from this ruling. Now, why do I say so? In an earlier decision of the Supreme Court, the Supreme Court was of the view, and if I'll refer you to the case of Openin Ejakwa versus Folagin, where the Supreme Court was of the view that demolition is an incident of possession. I would want to read that, what the court said in that case. It says, demolition is an incident of possession and can never be separated. So you cannot separate demolition from an order for recovery of possession. They go hand in hand.
So if the court gives you possession,
and
says this land is yours,
yes,
and there is a building or a structure on it,
yes,
it should also give you the order that you should go and demolish it.
Exactly. That is my view, with the utmost respect to the Supreme
That's if you want, because there's someone who will take his land back together with whatever is sitting on it and doesn't want to demolish it.
That is the person's business. So it is a matter of, if you decide that you would keep the property that has been unlawfully constructed on the land, then remember the risks that will be associated with it by another litigation, you carry it out yourself. But when you decide that the property on the land is an unwanted structure, you want it out of the land, to my mind, you should go back to the court that granted the order for recovery of possession, for the court to make another order, for you to go for demolition.
But as Veronica has explained, and with her experience working in the Lands Commission and all, this judgment is commonsensical. You have come to court and say the property is yours, yes, the land is yours.
Yes.
And for the benefit of our viewers and listeners, in law, not only in Ghana law, in law, when we say land, the law says land includes the solid surface of the earth, plants, crops, and other vegetation, a part of the earth surface covered by water, any house, building, or structure whatsoever, and any interest or right in, to, or over immovable property. So when we use the term land in law, it means more than bare land. It could be bare land, but it could also mean anything you find on top of the bare land. If it's a house, if it's a building, whatever it is called land. So, let me just go to this. The courts, through the Chief Justice, had cause on the 31st of May, 2021, to issue a circular, and it is titled Demolition Orders. And the circular was directed to all magistrates, trial judges, and justices of trial courts. It reads, the office of the Honorable Chief Justice's attention has been drawn to a creeping practice or procedure by some trial courts ordering the demolition of immovable properties, either as an independent relief or when granting leave for writ of possession to enforce judgment for recovery of possession. Enforcement or execution of judgment is regulated by Orders 43, 44, and 45 of the High Court Civil Procedure Rules, CI 47 of 2004. These rules do not provide for demolition as one of the methods for enforcing judgment. The rules only allow the registrar or the sheriffs to execute a writ of possession and give vacant possession of the immovable property to the judgment creditor, that's the victor. The demolition of any wanted structure on the land is the sole responsibility of the judgment creditor and not the court. Trial magistrates, judges, justices are requested to comply strictly with the above rules of court and avoid granting orders not sanctioned by the rules of court, such as orders for demolition. Signed, Justice Eni Yeboah, Chief Justice. Veronica, this is exactly the point you are making. Is that not so?
Exactly.
Hello, Veronica. Okay, please unmute your mic. Okay, so I just wanted, Mrs. Veronica Frimpong to comment about, yes, if you heard my question, what's your response?
Something that is simply the explanation I give. I do concede that there are challenges with execution. Like Bright said, sometimes the judgment debtor has sentimental attachment to the property and may not want to let it go. But even if you demolish the property and build and they want to come, they could still come. It is not as though there is no remedy open to you if this judgment debtor keeps coming or surfacing after you have taken possession, because it simply means that the person is disrespecting the orders of the court. And so you can cite the person for contempt. If there was no other remedy, then I would fully agree with Bright. But I do concede that there are challenges. But I believe that if the Rules of Court Committee sees going forward that there is the need to have some amendments to the CEI to make room for some of these provisions, they would. Also so that the judges would not abuse it, because otherwise it will appear as though after getting your writ of possession and taking possession of the property, you still have to go back to the court for a demolition order, which I believe should not be the case.
But Bright has just enumerated the difficulty, which you also admit. Yes. That if the court simply says, we have held you to be the victor in this case, the person on the land is not the right person. So we have ordered that that person moves away, you should be on the land, and if there's any property on it, you should be, you should take over. So if we have been adjudged the owner, you should do what you want to do with it. It shouldn't be for the court to say anything else. And if you have any difficulties with that, Bright is saying the difficulties which you also admit is the reason why the court should understand that there should be a demolition order rather than going to get a demolition permit from the assembly.
The assembly.
Yes. And if you get the demolition permit, what do you do with it?
Something. Is it the case that you couldn't take possession of the land at all, or you have possession and you want to demolish and you're having difficulty demolishing? Perhaps if Bright explains that, because my point is that if you have taken possession of the property in execution of the writ of possession, the property is yours. And that is what I understand the judgment to be saying, that the property is yours. We can talk about where you are having difficulties taking possession of the property, and that's a different conversation altogether.
Right. Samson. She's saying you have other reliefs. If you have been given the land, it's yours. If the person who has been adjudged not to be the rightful person to be on the land continues to flout the orders of the court, you can cite them for contempt. They will go to jail. They will pay money and all of that.
Yes, I agree. I agree that you can enforce a judgment by committal for contempt. But in the scheme of affairs, that should be the last resort. So if you even look at the rules, you will see that committal is the last resort to enforcing any judgment. And you know that is also another procedure altogether. There have been circumstances where judgments have been given, execution completely levied, and the judgment or the victorious party has been put in possession. Yet the loser comes back, takes possession again, you cite him for contempt. In fact, he is convicted, sent to prison, he comes back. Now he comes back in a different form. He comes back challenging the judgment that has been given. Why? Because he has a structure, for example, on the land. Before he was sent to prison, he pleads with you that let me go and come and relocate my family, for example. On humanitarian grounds, you decide that let's do so. Let's give him the opportunity to go and serve his terms and come back. And when he returns, he rather comes back with a fresh action against you. That comes back to add up to the cases.
And in the contempt situation like that, the person could go to jail for a maximum only of 6 months?
6 months. Even this one, 14 days. Mm-hmm. You understand? He comes back and still, because he still has some attachment with his structure on the land, now he comes in a different form. He now issues a writ, challenges the execution that was levied. What is happening? All these come to add up to the cases clogging the justice system. Vero spoke about demolition permit. The district assemblies are empowered to grant demolition orders. But I can tell you for sure, if you look at the new building regulations that was passed in 2022, Regulation 19, it talks about demolition works. If you look at this regulation carefully, it even worsens the case as to the circumstances under which a person may apply for demolition. For example, as we are here, it appears our focus is on judgments or enforcement of judgments.
Right.
But when we look at Regulation 19 of LI 2465, it talks about a developer who seeks to demolish structure must obtain a demolition permit. The definition of developer, unfortunately, also creates a problem. So, for example, I own land. My land is a farmland. Somebody enters the land and then puts up a structure in a corner. And then I obtain judgment against that person. I want that structure removed. From the definition that has been given by LI 2465, I may not be covered or I may not have the boldness to go for demolition permit. And that is how serious it is. And that is why I think that in circumstances like this, the courts, that is the superior courts of judicature, based on their inherent powers as conferred on them under Article 1264 of the Constitution, should be able to order demolition of such structures. And if that is done, it means that the poor man who obtained judgment will also be covered. If you read LI 2465, I stand to be corrected anyway. The poor man, I'm telling you, may not be covered because the definition of developer that I'm not sure has in contemplation the poor person. If you study it carefully. So it is my candid view that based on Article 126 Clause 4 of our Constitution, the courts have as part of their inherent powers the right or the powers to order demolition. If we say the courts do not have it, then the Assembly also says this. And in fact, there are times when we had judgment, we went to the Assembly for demolition permit. The Assembly sends you back and says, go back to the court and ask for demolition order. You get the scenario. Because the Assembly fears, I'm sure they have also realized that there is a gap in the LI which sanctions demolition. So they ask you to go back to the court. Now the court says that, look, I cannot grant you demolition order. So what do? Then the individual who is victorious take the laws into his own hands. Can we imagine the chaos? And indeed, that is actually what is the cause of the chaos that we see these days, where properties are demolished overnight. People use different tactics, some national security persons, military, and so many people. You see, we have rather created an environment for lawlessness to prevail. I stand to be corrected because when judgment is given, the court that gave me the judgment should ensure that I have peaceful and quiet possession by recovery of possession. Okay. And that is what the rules actually, I think, are contemplating that the judgment that a creditor should have.
Veronica, what will you say as a counter to the suggestion that this actually creates chaos? And we have seen the situations where police, military, national security, and we are showing you even some of the footages where demolition exercises, you see the police, soldiers all around demolishing and so on and so forth, because somebody who has lost a case, somebody has won. And we know what happens in this country. They say once you get onto the land, and even you hear that land it belongs to somebody, they will tell you develop it fast. And there is a certain notion, very wrong notion, that once you develop and you get to the lentil level, it will not be demolished. Don't you think we do need these orders to complete the court's judgment that it gives you that you are the rightful person to, occupy the place?
Thompson, I cannot tell the circumstances under which these demolitions are being done. Mm-hmm. Because you may not know whether they even went through the court processes in the first place. Yes, Ali. Or they are just demolishing because they think they have the right to do so. But coming back to the LI, I haven't read those provisions that Bright is directing us to. But if we believe that there is a problem with the implementation of the LI, we may have to address that, because that is not the reason why we should keep compounding the processes that one will have to go through in court in order to realize recovery. That is simply my point, but I do concede that there are challenges. Probably we should look at how to properly address the challenges.
Right. So even the Chief Justice had cause, as in Justice Ani Yeboah, to issue a circular to judges and say, don't be making orders for demolition. It is wrong. The law does not allow it. And now the Supreme Court says a high court gave a demolition order. the Supreme Court says that demolition order is unlawful. They've cancelled it. The court should not give a demolition order. Tell us, when does demolition of property become lawful?
I am not here to defend the judgment in any way, but I was expressing my view on my understanding of what the Supreme Court appeared to be saying.
Right, so how do I do it lawfully? If I get a judgment and the opposing person I have gotten a judgment against is still on the land because they have put a building on it and I have been given a judgment, lawfully, how do I go about demolishing their property if I want to do so?
Something I think the court hinted. You file a writ of possession and you recover possession of the property. I believe that the crux of the judgment is that it's not to say that you can't recover possession of the property. Recover possession of the property. Whatever you do with it afterwards is your business. So if the challenge is with recovering possession, that is what you should be talking about. But if you have recovered possession, like Bright is saying, the person, if you recover possession, it is yours. You can demolish if you want. But why wait if you think that the person may come back? The property is in your possession. You can recover it. And if I may add, probably the practice of people running to the court for demolition order is also the reason the assembly is also directing, like Bright experience, that you should go for a demolition order. So probably in the face of the Supreme Court judgment and then the directive given by the
Honorable Chief Justice.
The assemblies may view things differently. But I have a difficulty with the cancellation of the demolition order in the judgment because the person will still go ahead to demolish if he wants to.
That's right. Yeah. Now, Bright, a problem comes up.
Yes.
You win the case at the High Court or the lower court that the land is yours. So the property on it, go and demolish it. And the court gives you a demolition order. You go and you demolish. The person is not happy with the judgment. They appeal the judgment. And then at the end of the case, the appeal, they win. The Court of Appeal overturns the High Court decision. The property has already been demolished. Don't you see a sense in why the court says, the Supreme Court says, don't give a demolition order?
Samson, the analogy you have given, we can also liken it to applications for injunction. The rules provide that when an application for injunction is made and it is opposed, there should be an undertaking by the applicant to pay damages. Now, when you look at the rules on enforcement of judgments as well, before you recover possession of land, you must seek the leave of the court. And in your application, you must demonstrate to the court that the land over which you are seeking to recover possession is vacant or is not occupied by other persons who may have interests that the law may recognize. Now, it could also be that based on this application, based on the provision I referred to, the court can also make it mandatory that before the order for demolition is granted, the victorious party or the applicant must also file an undertaking to reconstruct the structure in the event that he loses. To my mind, I think that will be very helpful to all of us. Justice will be served. The victorious party would not feel as if he has got judgment and nothing is being done to protect the judgment that is in his hand. I can tell you, the circumstance we find ourselves now is a very serious one because most of the judgments in respect of land are paper judgments. I'm telling you, we are on the ground. We deal mostly in land issues. Most of the judgments are paper judgments, and most of the judgments we have got are being recycled all over. And these are factors clogging the system. And that is why we have to introduce the shift system.
Take my viewers through what the present process is if you want to demolish a property after you have secured judgment in your favor. And then let's begin to appreciate why we don't want to use that.
As it stands now, the Supreme Court says no court should make demolition orders. And that is the apex court. That is the final court of our land.
Right.
And that decision is binding on all of us for now, until the Supreme Court decides to depart from it. Now, when judgment is given, ordinarily, this is normally what is done.
Right.
When judgment is given, the law requires the judgment creditor, who is the victorious party, to have the judgment drawn by filing an entry of judgment. Remember, I am speaking purely in respect of landed issue.
That's right.
When the judgment is drawn or the entry of judgment is filed, you have the entry of judgment served on the judgment or the losing party. After service of the entry of judgment, if the losing party has any issue, he may appeal or whatever, or stay execution of the judgment. In the absence of a stay, the victorious party proceeds with an application for leave to issue writ of possession. So that is if the court has given you possession. Once the leave is granted, or before even the leave is granted, the court considers the content of your affidavit and finds out if there are people already on the land. If there are people already on the land, you must demonstrate that you indeed have given those people notice. So as I earlier said, that notice is to permit such persons to come forward should they have any interest in the land. When nothing is done and the court recognizes that, yes, you have followed the due process as laid down by the law, the application is granted. When application is granted, you now issue the writ of possession. After issue of the writ of possession, the registry will now act on it through the chief bailiff. A letter is written to the Chief Justice for police assistance. Now, the Chief Justice writes to the Legal Directorate of the Ghana Police Service. They forward it to the Regional Police Command for them to assist you. When all these procedures have been followed, the parties agree on a date for the execution to be carried out. Mind you, if you fail to execute your judgment within 6 years, you need to come to court for leave to issue writ of execution. After that leave is granted, you come back for leave to issue the writ of possession. Now, coming back to the police, when the police now are ready together with the court officers and a date has been fixed, the parties agree on when to carry out the execution. They enter the land to ensure that you, the victorious party, you are effectively put in possession of the land you have been adjudged. So this is basically a procedure.
We will open the phone lines right now. Call us if you have any questions for Emmanuel Bright Atoko or Veronica Frimpong, and about matters of possession of land or demolition orders. We'll be right back. You're welcome back. This is The Law. It's your legal light. It is your help law. It's our weekly legal clinic, and we give you platinum legal education. And here are two great legal minds helping us. Emmanuel Bright Atoko is head of chambers, EBA Law, and Veronica Frimpong is lawyer with Lex Kudos Legal Consult. She used to be with the Lands Commission. Our very first caller. Please, what's your name again? Oh, I understand the line just dropped. you can call us back and direct your questions to our guest. And okay, I'm seeing a lot of messages that you're sending in, but I want direct questions to the subject we are discussing in a manner that they can help you with answers, particularly if you are facing a practical challenge with having been declared a victor on a land, in a land case, and yet you can't seem to get the property back, or you can't seem to demolish the property on it and do what you want to do with it. Right. So whilst we pick a couple of calls, I like Emmanuel Techiman. What's your question?
Yes, so good afternoon.
Ima, go on with your question.
Yes, so my question is simple. This demolition thing, I don't know whether it is applicable to. So I'm asking whether this. In fact, good afternoon to your cherished listeners. What I want to ask is that this one is talking about somebody's land where properties are fixed on it. But what about a property that is impeding the right of way, a property that is fixed on a route? In such a situation, do you need a court order for you to demolish it? Especially when it is placed at a place where if you want to demolish it, people are going to rise against you. Let me give you a typical example. Your own house, the entrance to your house. If somebody puts a property right at your entrance, you need a court order, which will take several days, several months before it is granted, before you come and demolish that structure. I think the local governance has given us some kind of distance that when you see a property which is cited on a public right of way, you may, that the word there is may, and that is the problem, so it's discretionary. You may demolish it. You understand? But if you want to always rely on the may, the discretionary powers, people are going to do things, and at the end of the day, assuming your house is even burning because the person has put the property there, you cannot access that particular property because somebody has put that person there. Is it applicable to
Thank you for your question. Your question is clearly understood. Thank you very much. Emmanuel, he called from Techiman. You want to say anything to him?
Emmanuel, the scenario you have painted is quite different. The district assemblies are empowered to ensure that people do not build on waterways as you have stated. You don't need a court order. All you need is to address your concern to the assembly, for the assembly to take up that challenge. You don't take the law into your own hands and say you are going to demolish, and that can create chaos.
Right. Vero, there's a question coming in here that is asking, so after the court has adjudged me as victorious, and I go through the processes and go and get the permit to demolish, should I be demolishing at my cost when in a particular situation, the person was aware that he didn't have the right to be on the land, and the one party is running to court, and he was in a hurry to build very fast? That's a question coming. But let's pick Daniel in Abetifi before you answer that question. Hello, Daniel.
Yes, hello. Good afternoon.
Good afternoon. Go ahead.
Yes, please, I want to contribute to the program. Now, my contribution is you have a bare land, and then somebody has developed a property on it. Now, you have gone to court and you have gained possession of the land. Now, to me, I'm not a lawyer, but to me, you are supposed to pay for the cost of the property that has been developed on your land so that you can get access to your bare land. And that is the solution I want.
All right. Thank you very much, Daniel. I think that ties in with the question that came in earlier, which I put to you. Who bears the cost when you knew that it wasn't yours and you were still building in a hurry to take it over from the other party?
So those are all issues that would have been brought before the court. And the court has the powers to make orders as to who pays for demolition. Obviously, if the court believes that the judgment debtor should bear the cost of the demolition, orders to those effects would be made. So if those orders are made, the cost would be borne by the judgment debtor. But the second question, that you pay for the cost of the property so that you can peacefully take it, that is not the case, because the land does not belong to you. So if you build on somebody's land, you don't expect the person to come and pay for the property before they take over their land. The judgment is given. If the judgment creditor decides to do that, that is well within their power, because you have the right to even settle after a judgment. However, it is not the law that the person should pay for the cost of the property that the judgment debtor has put on the judgment creditor's property before the judgment creditor can recover possession of that property.
Right. So you must ask for it. Otherwise, you won't get it. If you are going to get judgment and you are getting judgment, you should be asking the court that I'm going to demolish the property on it. This person put it on it, and I want it to be demolished at his cost, not me, my cost. Exactly. You must ask for it.
Exactly. And normally that is what I do. I will include this as part of the reliefs, that an order for all unauthorized structures on the land to be demolished. In fact, I used to do it until the Supreme Court decision came.
Okay.
I would ask that all unauthorized structures be demolished, and the judgment debtor surcharged with the cost.
The losing party.
The losing party surcharged with the cost. Because why should the victorious party be the same person put to...
Now that you can't ask for demolition order, what will you do? I was going to ask Vero that question, really, because if you can't ask for a demolition order, how do you ask for payment by the party whose property you are going to demolish?
So that is where I said there is a challenge. And as I said, there's a challenge because the court says don't give demolition orders. The district assembly, you go to the district assembly, the LI 2465.
Right.
It doesn't cover what the explanation of demolition order is or demolition permit is.
Right.
It's also a challenge. So there's a difficulty. I think we have to look at the law again.
This is the law. It's always your legal light, and it is your help law. We want to say a very special 70th birthday to Mrs. Caroline Do Chikata. And this is coming from your family. Happy, happy birthday, Mrs. Caroline Do Chikata. 70th birthday. Live long and live in good health. My guests this afternoon on the law have been Emmanuel Bright Atoko, who is head of Chambers, EBA Law, and Veronica Frimpong with Lex Kudros Legal Consults. Ladies and gentlemen, thank you so very much for making time to educate our audience.
Thank you, Samson.
Right. All right, so that'll be it. Thank you very much. Have a good afternoon. I'm Samson Ladia Nyanini.